Good morning, everybody. Thank you so much for joining us for our March webinar. The year is marching on, most certainly. Today's topic is one that's quite close to my heart. You would have seen as part of our advertising for the webinar that as part of my master's thesis many years ago, I drafted a thesis on the constitutionality of body corporate rules. And with Friday being Human Rights Day, we thought that it might be a nice change of pace to look at the constitution of our country and its impact on our proprietary rights of ownership, as well as some of the constitutional clauses specifically relating to housing. So before we get stuck into that, and Razeen's going to be joining me on the discussion about that this morning, and then Razar, once he's done with the consultation this morning, is going to give us some inputs into how the whole constitutional aspect is dealt with in arrear levy collection and the attachment of immovable property. If you do have some background noise on your side, please do mute yourself. As always, a copy of the recording is going to be made available on our website afterwards. As part of the invitation, Kyle did share a copy of my thesis. Please keep in mind that I did embark on it in 2009. And a little bit has changed in the community scheme space since 2009. So if there's references to the sectional title schemes bill and the Community Scheme Ombud Service Bill and potential amendments, just bear in mind that it was quite a number of years before the legislation changed. All right, so on that note, Kyle, I'm going to hand over to you for a couple of announcements and then we can get going.
Thanks, Zerlinda. Good morning, everyone. I hope that you're all doing well, and thank you so much for tuning in this morning. Just a couple of marketing announcements. Like Zerlinda said, our webinar will be posted on our YouTube and our website, so please remember to like and subscribe to us. Then, if you haven't already, please do sign up to our newsletter, so this way that you will be able to keep in touch with the TVDM Consultants team. Then also, please make sure to join Trafalgar's webinar next Thursday, where Zerlinda will explore key aspects of HA governance, financial management, and best practices for maintaining a well-run community. Then our neighborhood live discussion will also be happening next Friday, the 28th at 9 a.m. Please note that this feature is only available to paid for members. If you'd like to upgrade your current package, please reach out to me. Then thanks. That's all the announcements I have. I'll add all the links to the chat.
Awesome. Thanks so much, Kyle. Raz, would you like to do a little hello before we get into the discussion? You're on mute.
There we go. Yes. Morning, everyone. I'll be grilling Zerlinda this morning. I can tell you that much.
Fantastic.
So yes, I look forward to it.
And I can promise everybody that Razeen is not wearing jeans on the lower half. He loves any opportunity to get dressed up in suit and tie, and he's got quite a number of them because he was a litigation attorney, having previously worked with STBB attorneys before joining us, the same with Razar as well. So if you'd like to reach out to Razeen or Razar, you're more than welcome to do so. They both have a lovely litigation edge to them, which makes our life in our consulting department quite interesting, most certainly. So today I'd like to start off with letting you all know that you can get a copy of my master's thesis. Kyle, I'll ask you to add a link to that as well. It took me blood, sweat, and tears over a 2-year period when I thought that my education was all I was ever going to achieve in my life. And now I realize, after having been a managing agent and being in practice for a number of years, that it is only really the beginning. And sometimes one can do what we do without having to go down the long route of getting a law degree and masters and all of those fun things. And that the discussions that take place in community schemes are ones that have an impact on all of us and ones that we can all contribute to. So I'd ask for today to be quite participatory. If you'd like to comment at all, you're more than welcome to raise your hand, pop a question in the chat function. And as I mentioned, we'll touch on levy collection and the impact of levy collection on your proprietary rights of ownership as well. So just as a bit of a high-level overview, we're going to be talking about, number one, our human rights when it comes to property and property ownership, residency in property, and of course, working in the property space. And we'll be chatting about justifiable and unjustifiable infringements of our proprietary rights. When I speak about proprietary rights, I'm speaking about our rights of ownership of property. And property is not only immovable property, it's movable as well. But for the purposes of our discussion, we'll keep it to immovable. So units in sectional title schemes, urban in homeowners associations, rights in retirement schemes, life rights, share blocks, all those fun things. And when it comes to justifiable infringements, it's when we believe, oh, can the body corporate tell me that I'm not allowed to have 5 dogs and a cat? I have a constitutional right to it. Or is it okay if your rights are limited, provided that the rights of others are upheld as well? So I know it seems to be a little bit high level, but when I start talking about the relevant cases and a couple of examples, then I think it will become a lot clearer to you as well. We'll also be touching on some foreign jurisdictions and how South Africa ties into those and how South Africa is quite different from those as well. We often in our consulting practice engage with clients from different jurisdictions, Germany, for example, people from Singapore, from Dubai, from the United States, from the UK, and community schemes are all treated very differently wherever you go. During my studies, I looked at Germany, the USA, and Israel. Israel, because it was the closest to our sectional title legislation, and then of course Australia, which we all know strata title is very, very similar to sectional title. And then I was very interested in condominiums in the USA, and I was extremely interested in the enforcement mechanisms in jurisdictions such as Germany. So we know in South Africa that we can impose rules and regulations and fines and all those things in community schemes. But when it comes to people's right of ownership, we can't evict tenants. We can't get involved in who can reside in a community scheme and who can't. We can't evict owners. And we can't sell owners' properties unless we follow the litigation steps. Just please do mute yourself if there is some background noise on your side. And Carl, if you can just help me with that.
Okay.
There we go. I think everyone's muted now. All right. So we have to follow quite a lot of litigious processes in order to get to the point where we're able to attach a property for outstanding levies. And we know that there are some considerations that come into play that Razal will touch on, and that is if it is a single female-headed home, if there's minor children, if the property is rented or vacant, and all of those fun things. So there's quite a lot of considerations to take into account. Now, some elements of what I'm going to be chatting about, one would think, does it really relate to our constitutional rights? And the one that I'd like to start off with is the keeping of pets. So we have a case, and it is the Laguna Ridge scheme versus Dorsey matter. It's quite an old one. I'll add the links and things like that, where an owner was refused to keep a doggy in a sectional title scheme. And she argued that the trustees did not apply their minds reasonably to the application, and that each application must be treated on its merits, must be considered in its merits, and the trustees can't simply impose a blanket ban. So the keeping of pets, we know in a community scheme, is a big one. For those of you that follow me on social media knows that I've got 3 big dogs, and I've recently added a kitten to the mix. And looking at this little 9-week-old kitten, I can't imagine that it could be considered to be a guide hearing assistance cat, as we sometimes receive applications for. And I most certainly can't think that my 3 dogs are guide hearing or assistance animals either. They are most certainly support animals or emotional support animals. But I can't really apply that to forcing my animals to be kept in a small community scheme if the rules don't allow for it. So I would like to see from a show of hands or comments in the chat, who thinks that not allowing pets in a community scheme is a violation of one's constitutional right? So do you think that you've got a constitutional right to keep an animal or to keep a pet? And if the scheme says no pets, do you think that that would be a violation of a constitutional right? Thumbs up, thumbs down, hands up, hands down, comments in the chat.
Zerlinda, on that, I see we've got some comments.
Yeah, go for it, guys.
On that, in your view, what criteria would bodies corporate or should they consider when making decisions, about pet ownership? Because obviously it's going to differ from scheme to scheme. And I mean, we've seen it in practice where you've often got the person that requires a pet for medical or psychological reasons, but it happens to be, sometimes an exotic monkey, for instance.
Yeah.
So yeah, so it's something that I think is very difficult to put a blanket ban on. So I do agree with the judgment, but it would be good to have your view on the criteria.
100%. I'm quite pleased to say that the majority of people that have commented have said, no, it's not a violation of our constitutional rights. So no, we don't have a constitutional right to have pets. When it comes to guide, hearing, or assistance animals, that is also not a constitutional right. We in South Africa actually don't have any registered bodies to tell us what is a guide, hearing, or assistance animal. Foreign jurisdictions such as USA does, so it's very interesting to look at that. And we've seen, and I'm glad you brought up the monkey example, Razeen, we've seen that the Community Schemes Ombud Service in orders have allowed animals other than the traditional guide, hearing, or assistance dog to actually be allowed to be kept in a scheme with a no pet rule, or a scheme with a rule that limits the type of animals. They've allowed, in at least my experience, cats very, very often. And I believe that there was an instance where they allowed a monkey as well. I'm not trying to at all say that there isn't a benefit of having this type of animal, but of course we don't have any statutory guidance in this regard. Now, the issue that we do deal with in community schemes, more so in sectional title schemes, because the rules are reviewed and approved by the Community Scheme Ombud Service, is the need for a guide, hearing, or assistance animal. We hold quite a strong view that that needs to be a dog, and the dog actually does need to have gone through some training or qualification to actually allow it to perform a medical guide, hearing, or assistance animal role. We have seen veterinary reports as well as medical reports that provide for dogs being needed for let's say medical purposes that are not necessarily seen as the traditional guide, hearing, or assistance requirements. But I always use the example of a 90-year-old lady that has lost her husband, now needing to have her miniature Maltese poodle, and having a doctor's note for that. That's not something that can be enforced. So I'd very interested if you do have a couple of CSOS adjudication orders that you can share with us. And Carl, if you can just share my email address on the chat, where you've seen either you were the applicant or the respondent, where animals have been kept under the guise of guide, hearing, or assistance animals. Some of the things that community schemes can reasonably put in their rules, if they are going to move away from a complete blanket ban, is the limitation of the type of animal. I very often see that in a scheme, maybe a cat is allowed, but not a dog, or a dog, but not a cat. There needs to be a justifiable reason for that. So to give you an example, in an environmental estate where there is wildlife, it would be seen as being justifiable or reasonable to have a rule to say no cats, because cats are predatory and roaming in nature. However, if an application is made, the trustees or directors do have to take into consideration the specifics of the particular animal. Is the animal kept within the property? Is the animal kept on a leash? Is the area where the animal is going to be kept enclosed? And now, having joined the cat family myself, I see that there's quite a lot of interesting and creative ways of actually keeping your animal indoors, but there is sometimes a justifiable reason to not allow a certain animal. You can also restrict the number of animals. So perhaps you say only 2 pets allowed, 1 dog, 1 cat, 2 dogs, 2 cats. You can say that a certain size of animal is allowed or not allowed. I've dealt with rules as stringent as a certain centimeter from the ground to the ridge of the back, from the tip of the nose to the tip of the tail. You can deal with a couple of interesting things. And then, of course, there can be a lot of reasonable conditions in place in regard to the keeping of the animal, not allowing it to roam, having send it to doggy daycare if they're going to be at the property alone during the day, having to have somebody at the property all hours of the day or night, ensuring that it doesn't bark incessantly. When I was a managing agent, I dealt with a homeowners association that wanted to put a condition in place that the voice box of a dog be removed. I thought that was pretty hardcore and definitely not something that I agreed with. And another one where they wanted to put a slight electric shock fence around the property to prevent the pet from escaping the property. I was also very anti that, and I know that you get a couple of electric trigger collars as well. So for those of us that love animals, I'm sure that we're all shocked and in horror that community schemes could consider this. Myself, I'm at the moment busy selling my mom's property in a community scheme, and the trustees are on a hardcore mission to get rid of all the pets and turn the scheme into a not pet friendly scheme. And I'm threatening every day to become a trustee and go door to door to ensure that the pet rule doesn't get changed. So it is very dependent on the scheme, the residents, the type of scheme, the type of common property facilities, the size of the unit, the availability of gardens, all those fun things. And then last point before I hand over to Razeen for some of his comments is just a reminder that in a sectional title scheme, you cannot allow one person to do something and somebody else not. So you can't have a rule that says ground floor units with gardens are allowed to keep dogs or cats, but any other unit with a balcony and not a garden is not allowed to keep a pet. We also have quite a bit of debates around tenants being able to keep pets or not, and then visitors being able to bring in pets or not. And that, of course, has a big impact on short-term letting as well, or some type of holiday accommodation within a scheme. Razeen, any comments on the keeping of pets?
Just one. So I think that, cats and dogs are obviously the most common, but I've also seen it where having birds such as a parrot, a world of a difference to a lot of people. And, they've actually got medical reports to state that they feel, I guess, like they've got essentially a friend in the house. Um, so I think that there's an argument to be made that whilst cats and dogs are the most common, and perhaps, it definitely should be limited to that, there should be a clause in the rules which effectively provides, and obviously this is looking at it from more of an owner's perspective, to actually provide to that the trustees apply their mind on a case-by-case basis. Um, and I think that that essentially gives enough equality to everyone in the scheme, but at the same time does give the trustees power to regulate it effectively.
Perfect. So yeah, we can talk for a long time about pets. I'm interested to receive some of those CSOS adjudication orders that I mentioned. And of course, please feel free to pop any comments that you might have in the chat. I do see a couple of a couple of comments that have already come in. The next thing that I'd like to chat about is tenants in a community scheme. So as part of your proprietary right of ownership, you of course can yield the highest return for your investment. In other words, a community scheme cannot stop you from letting your unit. Now, this is going to be a super hot and big topic when it comes to short-term letting, so we'll chat about that as well. But from a letting perspective, I have consulted with trustees before that have tried to impose rules to say only certain units or certain number of units could be tenanted to ensure that the vast majority of occupation was done by owner residents, to ensure participation, to ensure that the rules were upheld, to not bring down the values of the property, and all sorts of weird and wonderful reasons. A body corporate or homeowners association cannot stop a unit or an earth from being let. Now, this brings us into vetting or requiring copies of lease agreements and all those fun things. We know in a body corporate that an owner needs to ensure that their tenant receive a copy of the rules, that they abide by the rules, that they accept responsibility or liability for the conduct of their tenants, that they ensure that the rules of the body corporate are not overridden in terms of the lease agreement, but there is no requirement to actually, number one, provide a copy of a lease agreement to a body corporate, and number two, having the body corporates give prior written consent or even meet and greet or interview a tenant. I have dealt with schemes where, as part of the security onboarding process, they require a tenant to come and meet with the building manager or estate manager to do the biometrics, to get a copy of the rules, to take them through the rules and all those fun things. I think that's good practice, but that cannot be a condition to allow or not allow letting. Another big one that comes in is if a tenant misbehaves, the body corporate, the homeowners association, does not have a right to evict a tenant or to force the eviction of a tenant. That is dealt with completely different case law. And most certainly the body corporate or the HOA does not have the legal standing in that relationship. They can't put pressure on the owner to get rid of their tenant, and they can't make the life of the tenant unlivable or unbearable within the scheme to force them out either. They have to be treated the same as anybody else in the scheme. And then I think the last one is something that the PPRA fights against quite heavily, and that is having accredited estate agents or rental agents. No community scheme can force that only certain rental agents or estate agents are allowed to operate within a scheme, and they cannot apply benefits for actually promoting certain agents from exercising their business within a scheme. So you can't say you're only allowed to use ABC Estate Agency because ABC Estate Agency sponsors our golf days, and ABC Estate Agency always brings in good tenants, and ABC Estate Agency pays X percentage of the outgoing levy or something along those lines. We can't do that. There are estates and body corporates that do push the line a little bit when it comes to that, but it's not something that is allowed from the PPRA perspective or from the CSOS perspective. Razeen, would you like to touch on the issue of tenants before we talk about short-term tenancy?
Yes, I will go backward from everything that you've mentioned. I think that I definitely agree with not allowing only certain estate agents and stuff. You're kind of creating these little monopolies, which I don't think even economically viable. So I think that that's a good thing. But also when you think about what trustees' fiduciary duties are, that can be breached then when you sort of bring in uh, only certain estate agents who you work with, and all those sorts of things. And it goes without say that if a percentage of levies went to that agent, that would be a whole different can of worms. So yeah, and then also with regards to tenants, one of the things that we often get asked is, can
I'm not too sure, Raz, if it's your internet connection or mine. You good?
Not sure either. Yeah, all good, all
Okay.
good, all good. Yeah, so like one of the questions that we often get is, can we compel people to have this in their agreement? And it's important to point out that that would be under the law of contract, and you can't kind of dictate what two people will contract to. So yeah, I think that's it. And we'll obviously discuss the Section 25 limitations, I'm sure,
Yeah.
at some later
Yeah.
on. Yeah.
100%. Ken has added the Competition Commission as well, most certainly. And I've heard some discussions with regards to short-term letting and the statutory regulation of amounts of rental as well. You also can't, in a community scheme, obviously say to an owner that you have to charge above or below a certain rental. We recently had somebody post in our homeowners association a house that they were wanting to rent out, and it was quite a high rental. And everyone was like, oh no, you can't possibly charge that rental in this HOA, and are you ridiculous, and etc. etc. I mean, nobody's got a right to tell somebody what they can sell or what they can rent their property out for, most certainly not. The higher the better, in my opinion. It gives me hope for my investment. Sandy comments here, she once had a rental agent ask if she could switch off, and Sandy's a trustee, switch off the utilities to a tenant. She strongly declined. Well done. So you most certainly can't switch off the utilities either to to a tenant or to an owner unless you've got a court order, and the body corporate can't get a court order against the tenant in the situation because your relationship is with the owner as the member of the scheme. Something else that comes up very often is the allowing or not allowing tenants into the scheme when they are in breach of their lease agreement. I've been asked very often by my managing agent clients as to whether or not the body corporates can refuse access to the scheme and access to the apartment when a tenant is in breach of their lease agreement. In other words, the owner, the landlord, has said, hey, my tenant is naughty, my tenant is not paying the rental, or he has trashed my unit, or whatever it might be. I'm in the process of evicting them, or I have even completed the legal process of evicting them. Please stop them from accessing the scheme. That is not an instruction that you can take on from an owner, and the tenant most certainly would have a spoliation action against the community scheme for not allowing them access into the scheme. Another thing that comes up often, and I'm sure that Rizal will chat about it, is the attachment of properties by the sheriff for sale and execution. And very often a body corporate security is asked to allow the sheriff of the court into the property. You can't deny the access of the sheriff of the court, but you certainly can confirm whether or not the sheriff does have the right to enter by requesting a copy of the court order or requesting the owner's attorney to actually contact the body corporate with the necessary proof. All right, so let's talk about short-term letting now. So when it comes to your right of ownership and to yield the highest return for your property, we sometimes believe, sometimes choose, sometimes not, that undertaking short-term letting is going to be the golden goose and is going to yield a much higher return on your investment than the traditional letting options. And in some cases, it is very, very true. Now, a body corporate can, and we know that they do, restrict, sometimes ban short-term letting. I know that the Community Scheme Ombuds Service back in the day used to not approve conduct rules regulating or restricting short-term letting. They wanted it to be in management rules, and as we know, management rules require an 80% quorum and 100% vote for an amendment, which is sometimes very difficult, if not possible, to achieve. The CSOS changed that approach and now do review and approve conduct as well as management rules regulating or banning short-term letting. In Cape Town, at least, we've got municipal bylaws dealing with short-term letting, but the only thing that it says is that they consider short-term letting when there is a particular reasonable period of time. And my body corporate, I'm aware, was the first body corporate in Cape Town to actually apply for a land use departure application through the local authority to allow units within the scheme to undertake short-term letting in compliance with the rules. So I'm not too sure if your scheme has gone through the process of applying to the local authority for a land use departure. Please do pop it in the chat. I'd be interested to hear that it wasn't just one body corporate that undertook the project, because it was a hell of a lot of work, I hear. But a body corporate can reasonably ban or restrict short-term letting. I very often consult with trustees that they're wanting to stop short-term letting because of conduct issues. In other words, it's the short-term tenants that come and make a noise and throw the parties and park in people's parking bays and all those fun things. When I was chairperson of my scheme years ago, we actually did a 1-year case study where we noted every single complaint that came in. And interestingly enough, more than 90% of the complaints related to units that were occupied by owners or long-term tenants and not short-term tenants. So it's not fair to say that all conduct breaches are conducted by short-term tenants unless there is actually proof of that. There are very often complaints that if units undertake short-term letting, they're applying an unreasonable burden on common property infrastructure. The gate is opening and closing too often, the elevators being used too often, the security guards are working a lot more than they would in any other event. So there has been CSOS adjudications that have permitted a body corporate to impose an additional contribution on owners that are conducting short-term letting from their units, provided, of course, that that would be justified. In other words, the body corporate would actually need to prove that certain expenses are being incurred for the sole reason of short-term letting. Now, for any managing agent online, I can imagine that you would agree with me to say that it is very difficult to actually put that together to say, yes, without reasonable doubt, short-term letting is incurring XYZ costs. The only additional cost that I've been able to reasonably agree with is if additional security guards or access controllers or concierge needs to be appointed to actually deal with the short-term letting. In my scheme, we ensure that in our rules, the security guards are not asked to actually assist with short-term letting. They can't assist you with your luggage, show you where to park, show you where your unit is. That is something that has to be dealt with by the owner or the rental agent or the rental business or operator within your scheme. So a body corporate should not be forced into going down the road of employing a cleaner to deal with units or to appoint a security guard to deal with access control or, pointing out where the unit is, etc., etc. The CSOS are approving rules that are regulating short-term letting to periods of 3 or 6 months. Again, we've also found in community schemes where they are wanting short-term letting only over certain periods, short-term letting over a certain number of days or weeks, short-term letting that only a percentage of units undertake it. And then, of course, there's the big debate about whether or not conducting short-term letting is actually running a business from a unit. So we're of the opinion, and I'm happy to see, I think that Mike Addison might be online, although he's on holiday, so I don't think he is. But if one of our insurance colleagues are online, I'd love to hear their view about the business element. In our opinion, short-term letting from a unit is not changing the use or the purpose of the unit. It's not a change of use, and it's not running a business. If I was using my residential units for the sole purpose of having a desk and a computer and actually running an Airbnb type platform, that would be something completely different. But actually allowing people to come and stay for a day or a week or a month or 3 months or 6 months is not running a business. I don't believe that it is any different from having a long-term tenant. I've also dealt with community schemes where they are not wanting short-term letting because they don't want an owner to actually yield a higher return for their property to the detriment of other owners in the scheme, and things like that are not reasonable. So from a constitutional perspective, we do have the right to reap the rewards or yield the fruits in terms of our Roman Dutch background in our legal system in South Africa. Short-term letting is not a constitutional right, but it's also not defined as anything different than your traditional letting or rental. Razeen, any comments on the short-term letting issue? I know that it is a hot topic.
100%, yes. By the way, Mike is tuned in, but he doesn't have a microphone.
Thank you.
So two things, and I'm sure that the first one you will discuss at some point is you obviously talk about how sectional title rules in your thesis must be reasonable and equally applicable. And there's, I'm sure, a plethora of rules that we can discuss which maybe crosses the line into being unconstitutional. But what do you think is sort of the most misunderstood aspect of, testing whether a right is reasonable and equally applicable? And also, do you think that Section 25 can be used to justify the limitation on short-term letting? Because a lot of the times, you've got like one of the main arguments you get when a scheme validly passes a rule to restrict short-term letting, and an owner refuses to accept it. Oftentimes, they come with the argument of, well, it's my right to property ownership, and I mean, we've had owners go as far as, through their attorneys, essentially say that under Section 25, it's not justifiable. So, what would you argue in that case? And once you've answered that, I'll tell you my second one.
That's a mouthful. I see somebody has posted on the chat about the mayor's view of short-term letting and changing to commercial rates. I did mention that in Cape Town, at least I'm aware, I can't comment on other municipal jurisdictions, that there is a lot of talk about regulating short-term letting, deciding in which areas short-term letting can be undertaken, deciding on how it, or what rather the quantum of the rental can be, what schemes would be allowed or not allowed to undertake short-term letting. But remember, that is a a statutory amendment that needs to be made. So we don't have anything at the moment other than, at least in our jurisdiction, the whole definition of what reasonable occupation is, and then that land use departure. I'd be interested on this comment that you made about the change of the unit's rates to commercial rates. I'm not aware of anything like that. So again, I'd be interested in hearing if anybody has actually got some experience in that. All right. So to answer your question, Razeen, when one looks at the Section 25 constitutional argument of reasonableness, you have to look at, number one, what is reasonable in a particular situation. So if I had to take the weighing scales of justice and I had to decide, I am the only person in the sectional title scheme that is undertaking short-term letting, everybody else is owner-occupiers. Does my rights outweigh those of the rest of the owners? Or if I'm conducting my short-term letting enterprise in such a way that I'm simply, stacking the tenants in there like sardines, I'm overcrowding, I am, getting a very low caliber of tenant, I'm not ensuring that they're applying by the rules, does my right to yield that high return for my investment outweigh the rights of my fellow owners? And that's where that test comes in. So the reasonable person would say, if there's only one person in the entire scheme that wants to undertake short-term letting, it's probably not going to be reasonable to force the body corporate to amend its rules to allow it, or to actually allow or force the trustees to allow it if there is a conduct issue. If one looks at the remainder of the occupancy of the units, are they mostly owner-occupied? Are they long-term tenants? Are they of a certain age demographic in the scheme as well? You have to look at the nature of the scheme. Is it in a certain area? Is it close to amenities and facilities? Does it have its own amenities and facilities? One has to take those into consideration when actually applying the reasonableness. In a scheme that has always allowed short-term letting, to suddenly stop it because one person or one committee of trustees have had issues, that could be looked at a different way. It wouldn't be reasonable to stop it in that type of scenario. So when we guide trustees on this point, we always suggest that they first look at the reasons for regulating or banning short-term letting. Is it conduct issues? Put the right rules in place, put the right procedures in place, have your security, have your access control, have your parking signs, have your noise rules, have the signage about your facilities, engage with the occupiers, engage with the owners, engage with the rental agents before you simply say, hey, short-term tenants are naughty, we're not going to allow it. The Section 25 right of owning property or having a right to housing doesn't specifically drill down into letting or short-term letting, but it is most certainly something that you look at from a right to benefit from your right of occupation, which in essence is commercial. So I can see where the whole commercial argument is coming from, but one has to consider it on an actual case-by-case basis. I'm just having a look at my thesis here, and I see that when I spoke about looking at the ability to pass the test of reasonableness, I say in order to determine this, the individual circumstances of each case must be considered as factors. If they are unreasonable, the rules will be invalid, and their enforcement would lead to oppression, partiality, and inequality. But it's difficult to apply as the community of owners, the body corporate represented by the trustees, is not a public law, state, or administrative body. The members of the body corporate are private persons. Therefore, the scheme is not managed in the light of public interest. So things that we would consider if we were dealing with our constitutional rights in South Africa and in politics in general is very, very different in a community scheme context when you're dealing with private individuals. We're not dealing with public land. We are dealing with private land and private individuals and our private right of ownership as well. Razeen, back to you.
Cool, thank you. Okay, so in light of, and I think we can go a bit more toward HOAs now. I think we've lost Zerlinda for a second, but in light of the recent Mount Edgecombe judgment, there's obviously where the court decided that when you buy into an association, it was an HOA in that case, then you're essentially bound by, the rules and regulations. It's effectively a contractual relationship. So we do find that HOAs have much more success with regards to regulating short-term letting, and they can regulate it essentially how they see fit and based on the nature and character of the scheme. So I guess it would be good to have that type of guidance within sectional schemes, but that also draws my attention. And Zelinda, I know you mentioned our other jurisdictions. And I've done a bit of research on Germany, and because I've traveled a few times through Dubai and the Middle East there as well. And in Germany, they have their German Condominium Act. I think that's how you say it.
Yeah.
And, effectively, people require a special permit to list certain properties. The law was softened to allow owners to rent out a room whilst residing in the unit. So I think, it's very interesting whether South Africa could adopt a similar approach. So I know in Stellenbosch that would then, that you would actually need to, I believe, apply for a land use departure application.
Yeah.
I stand to be corrected, but I strongly believe that is the case, according to their municipal bylaw in Stellenbosch. And then in the UAE, they have holiday homes regulations. It's not very formalized. However, you do have to apply for a permit through the Dubai Department of Economy and Tourism. And anyone who's ever tried owning a property in Dubai will know, or in the UAE for that matter, will know that it's absolutely horrendous. You'll end up just deciding not to, unless you've got millions and millions to throw at the issue before actually owning the property. But that's neither here nor there. Uh, Owners in freehold buildings there need to obtain approval from their homeowners association, if you want to call it that, before registering their property, for short-term letting. And they're very strict there when it comes to, compliance with their laws and things. Um, so again, it raises the question, should South Africa introduce a licensing system? Perhaps Cape Town, under their municipal bylaws, could introduce. It doesn't need to be as stringent, but at least you have actual numbers to work with instead of, going on a basis of just public opinion or just what we think, is incorrect and correct. So, there's more regulation that way, and there's more recourse for both bodies, corporate and owners. So I think that these are very interesting questions.
I don't want to focus on the change of use element and the business element too much, because again, like you said, it's different jurisdiction to jurisdiction, and municipal bylaws deal with it. The Stellenbosch one is a lovely example, and I think it was all the naughty students over the years that have sort of like made that municipal requirements. But there is also quite a lot of case law relating to whether or not a unit may be the purpose of the use of a unit can be changed, and whether or not running a business is allowed. So we know that we get mixed use schemes where there is a business component, maybe commercial on the ground floor, residential on the units above or the floors above. We know that you have to look at the zoning scheme requirements. And we know that one has to determine whether or not the running of a business is actually detrimental against other individuals' rights within the scheme. So to give you an example, I live in a homeowners association and I work from home. So I am running my business from home, but my clients don't come and see me at my house. My staff don't work with me at my house. So there's no security risk. There's no additional parking. There's no pressure on resources. I'm sitting quietly most days behind my computer, using my own electricity, my own Wi-Fi. I'm not complaining if the dogs next door bark all day or the children come home at 2 o'clock and make a noise. I adjust my schedule around that. I don't go and stand outside making a noise, or I'm not making food that has all sorts of smells. I don't have staff coming and going. I'm not using any instruments or tools that make a noise. So those are things that you need to take into consideration as to whether or not running a business from your property within a community scheme is considered to be a constitutional violation or not against anyone else's rights. I have, after COVID, dealt with a lot of different complaints in community schemes than before, with people working from home, Suddenly, we start complaining about the quality of our internet supply through common property. We start complaining about not having enough parking. We start complaining about the children coming home at a certain time. We start complaining about the quality of the units because sound is penetrating a lot more and we're more sensitive to it than we previously would have been. We're complaining about the time that the gardening service is coming and going and making a noise. You need to obviously take that into consideration when making the argument as to the body corporate not upholding your right to run your business. And remember that it is a residential scheme and you need to fit in with that. But simply saying that you're running a business and that's not allowed, again, is not a simple, straightforward or cut and dry issue to deal with. Razeen?
Yeah, I think that, I often take the general approach that when it comes to schemes and, it comes to a balancing of rights. You always balance the rights of the collective owners versus the right of one owner. And when you buy into a scheme, you effectively are buying into a shared living space. So, so I think that that's very important to note when it comes to certain complaints, because we have had CSOS cases where for example, there's a commercial, it's actually a fully commercial scheme, and a person may run a call center, and the person across may run a shop, and the person in the shop makes a CSOS application because the call center is, making too much of noise because there's too many people talking all at once. But that is kind of the nature of a call center. So
Yeah.
it's definitely, on the basis of reasonableness. And when you buy into a scheme, whether it's commercial or otherwise, you have to, again, we go back to Zerlinda's thesis on the principle of reasonableness. The last thing with regards to, I think, at least from me, for short-term letting and with regards to the foreign jurisdictions, it's very interesting because Catalonia, I believe that's Barcelona, sued Airbnb for failing to enforce compliance with their bans on short-term letting. And there was actually a complaint filed with the EU, the European Commission, or the European Union's Commission, and I'm not sure if it has been adjudicated on it yet. But it's very interesting, whether South Africa will follow that route. Will they explore litigation against platforms like Airbnb if illegal short-term rentals become a persistent issue? Um, Perhaps it could be in public interest even. So, yeah,
Fantastic. Let's
that's
shut
just a
down
point
the
of interest.
discussion about the short-term letting and let's move to the arrear levy collection issue. I see Razar joined us a couple of minutes ago. So this morning in our team meeting, I said to Razar, before I throw you under the bus and I throw a question at you, let's rather discuss what you feel comfortable about chatting with. So Razar, thanks for joining us. Razar is based in the UK and community schemes there are also very, very different. And he joins us from STBB Attorneys and he held the portfolio of levy collection. So I know that he's dealt with a couple of interesting cases. Before we hand over to Razar, let's chat about penalties and fines that are sort of like lead hand in hand with legal fees and arrear levy collection and contribution collection and things like that. And for those of you that didn't know, we're on our third generation legislation. So the 1971 Act was the first, the 1986 Act was the second, and the 2016 Act the third. And in the 1971 first generation legislation, we actually had domestic tribunals. And those were entities made up by laypersons, almost like an advisory council like we have today, that actually looked at whether or not something was deemed to be a contravention and empowered trustees to impose fines or actually allowed a body corporate to enforce its penalty process. And having any form of tribunal in the hands of laypersons is obviously subject to abuse. And this disciplinary committee was actually removed in the second generation 1986 legislation. And one can argue that it was put back in place in terms of the 2016 legislation with the Community Scheme Ombud Service, but we're not dealing with laypersons here. We are dealing with an entity that has been created in terms of statutes. So it's interesting that there has been this, about turn in the legislation about involving an independent external party or group of people to actually allow or disallow or engage with private contraventions private rules and private disputes when it comes to the enforcement of fines and penalties. And I think, Razeen, I know that you love research. Maybe it might be an idea to actually compare in a blog post or something along those lines this domestic, this domestic tribunal with the CSOS. On a reminder, Nicole Null, who's not with us today, she's enjoying some well-deserved leave, wrote her master's thesis on the community scheme ombud service. So if you're interested in having a look at that, perhaps Carl can just post that on the chat as well. All right, so Razaan, when we chatted this morning, we spoke about a couple of different scenarios where pursuing a owner that is in arrears with their levies would be a good idea from a body corporate's perspective, or a bad idea simply because when one gets to the point of having to attach the immovable property, in other words, having to attach the unit for the arrear contributions, it is an argument to be made that might be unsuccessful by the applicant body corporate or homeowners association or other form of community scheme, because the respondent or the defendant's right to housing in terms of the Constitution will actually be upheld above the body corporate's right to recover the levies. And we spoke about the quantums that a collection attorney would feel comfortable with in actually pursuing the legal proceedings. And in your absence, I mentioned a few things that the court looks at. They look at whether or not the property is tenanted, in other words, an investment property, or owner occupied. They look at whether or not the owner is unemployed or employed, has minor children, is a female or not. So there's quite a lot of considerations to take into account when dealing with arrear levy collection. Would you like to make some comments?
Sure. Thanks, Zerlinda. So I mean, it's not a question of whether or not we should pursue the levies. I mean, we have to pursue levies. It's the lifeblood of the sectional title scheme. But I mean, when it comes to specifically declaring immovable property executable, I mean, in my experience as a collection attorney, I think when we get the handover, that's where the body corporate's mind is at and say, let's go and attach the unit. So obviously, we're putting the cart before the horse if we're attaching the unit from the outset. So there are steps that we need to follow before we can go that route. But I won't bore you with the details of the entire collection process.
That's a different
Yeah. So just to your point of declaring a unit executable and also just balancing that right with the right to housing, Section 26 of the Constitution. So there's various factors that the court will take into account. And there's preeminent case law, Jafta versus Kuman, that deals with this, and it offers us guidance on what the court will consider. A few of those factors being what attempts have been made to date to recover the debt. Is there any, or pay the debt? Is there any alternative recourse available for the body corporate? The financial position of the parties, and also is this the primary residence of the judgment debtor? So I mean, 46A, which is the Uniform Rules of Court, also deals with it and sets out certain factors that must be listed in your application to court. And I think the overarching requirement being that there must be judicial oversight. So it's not a rubber stamp process of, look, we're making this application, the judgment debt is in debt, here with your order. So there are various factors, and also from a constitutional point of view, that the court will take into account. Obviously, we know that you can limit constitutional rights if it is reasonable and justifiable. And I think you, Zerlinda, might have spoken about Section 36 of the Constitution
Not yet.
earlier. Not yet. I'm late to the party, so I
No,
thought it
go
might
for it.
come in
I hand over
discussion.
to you.
Yeah. No, so it's in essence what Section 36 of the Constitution says, that there are human rights that can be limited in certain exceptional circumstances, and obviously it must be reasonable and justifiable. And then it goes on to set out certain requirements that must be taken into factors that must be taken into account when limiting those rights. Yeah, I think from a collection standpoint, that's all that I can comment from the interplay of collections and the Constitution. I don't know, Zerlinda, if you have anything in your experience that you can add to that.
So, I mean, when I collected levies and with you doing it now is two different times, and obviously under the previous legislation. But I remember when we drafted Section 66 applications, which was for the attachment of the immovable property, you actually had to really set out to the magistrate or to the judge about, well, in this case, magistrate rather, you had to set out how the body corporate's rights and the rights of the individual members within the scheme outweighed the property rights of the owner, and how the property owner essentially flouted their obligations to the body corporate, and the obligations were then reasonable and justifiably infringed that right of ownership. And in a community scheme, it's so much easier to argue that than any other debt. And levies are not a normal debt, of course. And one looks at the fact that you voluntarily buy into a community scheme, you automatically become bound to the legislation, automatically bound to the rules of the body corporate, which is why it's so important to ensure that the rules of your scheme, be it a homeowners association, whatever type of scheme, that you are actually dealing with the arrear levy collection process. Our colleagues at Stratafin have a policy that they actually put out as a template on their website at no charge that they really recommend, and Quentin Barnard as well, when he drafts his governance documents, sets out this policy that the members, when they are buying into the community scheme, immediately know what that policy is going to be and how their right of ownership is going to be infringed, for lack of a better word, because of this policy and this set in stone process that the trustees or the directors are going to follow. We had an interesting discussion with Marina the other day after she spoke about it on Women in Sectional Title platform, about approaching the banks to do a bit of an affordability test on owners, not only if they, or potential purchasers in a scheme, not only if they can afford the bond payments, but if they can actually service the debt that is going to be incurred as part of their ownership in a community scheme. In other words, the levies, the special levies, the exclusive use area contributions, any other charges, interest, recovery charges, and all those fun things. Razeen, I know that you were on that call. If there's anything interesting that you'd like to share with our attendees today.
Yeah, I think of interest to me would have been the discussion regarding the banks and them taking what's owed to them and then washing their hands of the matter at sales and executions. So what we spoke about is that we need to lobby together as colleagues in the industry, and we need to find a way in which the banks are jointly and severally liable for the levies owed to the body corporate as well. And I do know that colleagues in the call, they're thinking of forming a committee to take this matter forward and take it up with the banks and the CSOs and so on. Obviously, I would opt into that committee and push and try and advance this objective. But yeah, they also went on to speak about details of sales and executions and how people are showing up there and hijacking these sales and executions. I think that's a bit off topic, but I mean, we can have a separate webinar where we delve into that.
Yeah, most certainly.
Yeah.
I'm glad that you raised the issue of Section 36 of the Constitution, and I'm not going to give everybody a property law lesson here. But if those of you are interested or have time, we're going to share the details of a case that I'm sure will give Zerlinda and Razeen nightmares, because I know it did me when I was studying. Is the First National Bank of South Africa, Westbank, and the Commissioner for SARS case, where it deals with the whole Section 36 issue. And there's a couple of issues that it looks at. It looks at who is making the application. So what is their interest in the property, whether or not their rights of ownership has been deprived. I mean, that's a pretty hectic term to use. If that deprivation has been, I've been speaking about the word very often, unjustifiable, or if it's been arbitrary. So very often in application of rules, we say that the application mustn't be arbitrary. It must be applied equally. It must be applied reasonably. And then, of course, the issue of reasonableness is very different from person to person, let alone scheme to scheme. So when we're looking at community schemes and the change of trustees and the change of committees, one would need to ensure that there is enough processes set out in the rules to actually guide those trustees, that what they consider to be reasonable today and what the next committee considers to be reasonable is not simply, willy-nilly, so like completely out of kilter. So yeah, there's a lot that we can still discuss on this topic. For those of you that are interested, there is some reading material. We'll share that with you. Serena, yes, there is going to be a recording of the webinar available on our website, and we'll post it on social media when it's ready. We spoke about a couple of cases that we'll share as well. Rizal, thanks for jumping off your consult and joining us. I'd like to open it up to the floor. We've exceeded time, so if you need to go somewhere, you're more than welcome to hop off. But if there's any comments, any questions that you'd like to raise, please feel free to raise your hand, unmute yourself, and we can have a discussion for a couple of minutes and see whether or not you found this topic of interest, especially in your day-to-day management, either as trustees or managing agents or anything in between. Attendees, over to you.
I see that there's some questions from Catherine and Debbie.
Okay, let's open it up to the floor first. If there's anyone online that would like to unmute themselves and participate in the conversation.
Hi, Rizal, how are you? Can you hear me?
Hi, Catherine. Yeah, very well. Thank you. I can hear
Oh,
you.
great. I'm sitting in a Dubai that's starting to get very, very hot and trying my best to be a good trustee from here in South Africa.
Good.
Now, I'm sitting in London and trying my best to be the best attorney from here.
Oh my gosh. So we actually had a meeting last night, and the MA had stated that she wants to leave the group of attorneys that we're with because she suspects there might be unethical practices going on. I couldn't hear properly. I'm waiting to transcribe the recording, but that they were actually sending people in and they were purchasing the properties that were for sale in execution. So they apparently want to look for new attorneys, but that's something different. But some of these, I've started looking through these because I'm fairly new as a trustee. I did an MA course through Paddocks, and
Awesome.
can it take up to 3 years for attorneys to process a sale and execution? Once all the procedures have been followed, the letters, it's now at the attorneys. Can it take 3 years for them to process before a sale and execution actually takes place?
In my experience, it hasn't taken so long to process it. So, I mean, that's a bit of a red flag. But as you know, each matter is unique. So I don't know what the facts are in that matter. So I mean, it's not impossible, but it's not common.
Okay, thank you. How long would it normally take, would you say, Rizal, from the time you've handed over to an attorney?
I mean, Catherine, how long is a piece of string, eh?
Okay.
I've heard of a year. Speaking as a trustee and speaking as a managing agent and speaking as a collection attorney, you can only move as fast as, number one, the legal process allows you to, and number two, per your instructions. So
Okay.
my advice to trustees is to ensure that from the word go, you've got that collection process in place, that your instructions to the managing agent, to the attorney is, the levies are due and payable on the 1st of the month. By the 7th of the month, a final demand has to be set or a friendly reminder set. By the end of the month, a final demand has to be set. The managing agent on behalf of the body corporate has to send that final demand. Then a collection attorney is appointed from a panel or a collection attorney that the managing agent or the body corporate likes to work with, preferably someone that, number one, has the capacity and number two, has the skill set, because recovering debt versus recovering levies is two completely different things. So that would also have a big consideration to play for the timeline. And then they've got the instructions to go, that they mustn't come back to the trustees for, oh, we've issued summons, what now? Oh, the sheriff of the court says there's been a nulla bona return, what now? Oh, the guy has come to us to say that we must please give him 30 days because he's getting a new job. Or, oh, he wants to sign an acknowledgement of debt. Or, oh, he's made a 500 Rand payment on a 10,000 Rand debt, or whatever it might be. You need to have very strict instructions that are given through. And if the attorney has those instructions from the word go, that they know that they don't have to first speak to the managing agent, speak to the trustees, wait for the trustees to meet at their quarterly meeting, blah, 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 that they can just hit the ground running, and that they've got a dedicated individual or team to do so, I don't see, all things being equal, that from the moment the final demand gets issued to actual sale and execution should be anything more than a year. Of course, during COVID, it delayed things with the courts going onto an online system. It's different. Joburg courts versus Cape Town courts are different. Having tenanted properties versus vacant properties or owner-occupied properties are different. HOAs versus body corporates are different. But I do agree with Razaa that 3 years is a bit long. I don't like what you said at all about the attorneys are the ones that are purchasing the properties. So you have to have a proper collection attorney. And there must be a clear instruction as well.
Thank you very much.
Yeah, that's what's always very important to have for the trustees and the collection attorney, to have that relationship where the attorney knows that I can go as soon as I have as soon as I get anything back from court. So it's not toing and froing where I get an order back from court, I have to scan it in, send it to the trustees and get the instruction. So there must be an outright instruction that you can go and we trust your judgment.
Yeah.
Obviously keeping you apprised of the process as we go along. But I mean, if there's illegal boxes that must be ticked, an attorney can carry that forward and doesn't necessarily have to consult trustees.
Yeah.
Thank you very much.
A little bit off topic, we had a call with trustees a little while ago. Razaa, I think you were on the call with me, where the client was like, you've sent me this document for instructions, but like, I don't know, you need to give me the advice. You need to tell me what to do. And, I took my lawyer cap off and I was like, imagine I was that trustee getting this legal document thinking, okay, what the heck? I don't know what to do with this. And I said, well, if I were you, I would do X, Y, and Z. And because of that confidence or conviction, they were like, okay, fantastic, let's do that. As a trustee and you're getting a debtor's report and it speaks about service of sheriff and sheriff was not available and sheriff's fees and blah, 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 blah. You don't know what's going on there. You rely on the contractors or the service providers that you've appointed to tell you, this is the situation, this is what we think you should do, yes or no, if that, in fact is the process that needs to be followed. Sandy, you had your hand raised next.
Good morning, all. I just want to position something with you. As you know, we've got conduct rules, we've got prescribed management rules, but unfortunately, we also have, or fortunately, depends on how you look at it, we've also got bylaws. So this has been on my mind for quite some time now, to actually have some kind of like event, maybe in person, like an informal, to say, okay, what does a bylaw say in terms of the specific area? So I'm thinking of doing one for my area so everybody understands, because oftentimes you find people understand conduct rules, but not necessarily prescribed management rules, and perhaps even less so the bylaws of the municipality. And it differs from Joburg to Ekurhuleni to Cape Town.
Yeah.
And is in terms of valuations as well, that's another very hot topic where people don't understand how the valuations are done for insurance, for selling a property, and for municipal valuations, and being able to separate the three. So, that's just a comment that I've got from our side. Thank you.
Awesome idea, Sandy. I mean, if you think about different jurisdictions, you can even look at a bigger picture from a homeowners association perspective. Carl spoke earlier that I'm going to be chatting to Trafalgar about different types of homeowners associations. And in Cape Town, we've got mostly common law associations, but we've got a couple of companies as well. In your neck of the woods, you've only got companies. In KZN Eastern Cape, you've got municipal ones and companies, and all the municipalities are different. The requirements for the Constitution are different. So I think it's a great idea to sit down in individual communities to actually look at that, or have a forum like you do, with your WhatsApp group to answer these types of questions. Very good idea. Hazel, your hand is next. Hazel Rademacher, if you can just unmute yourself.
Can you hear me? Sorry.
Yes, yes, we can.
Okay, we're on. Okay, it showed. Thank you so much for a wonderful webinar. It's so lovely to hear your expertise. And my questions, I've got two. One is the levies. Can they be prescribed?
Yeah, that's a hot one. Razeen, I'll put.
It's all my questions are always like that. But I have a situation where I have the municipality laying due for several years worth of levies. Okay, they have a dispute on because they say they weren't notified that it was increased and they weren't this and they weren't that, and they are only prepared to enter into discussion for the last 3 years worth of levies. Right now, they have had tenants in the property, they have received rentals. So as far as I'm concerned, I see no reason for them to be able to go to the prescribed rule. But they have just put their foot down and they're not paying the levy.
Yeah. So with your question about prescribed, you literally mean in terms of the Prescription Act, right? That after 3 years.
Prescription Act, they are saying that they will not go further back than 3 years.
Okay. Razaan, do you have a view on the prescription of levies issue? You're on mute. Razaal's going to say, "Oh no, my audio stopped working with this question."
Sorry, can you hear me? No, I know it's a contentious issue in the industry and there's conflicting views.
Thank you.
I've been privileged enough in my tenure as a collection attorney not to deal with a matter where this issue came up. But Zerlinda, I don't know if you have experience with prescription and levies. I mean, it shouldn't come to a point where the levies are at a point of prescription.
Yeah.
So we must act timeously.
Yeah. So remember, when it comes to levy collection, it's something that is ongoing. So you constantly have
It's a moving debt,
yeah, and you're constantly getting some form of payment in. And there's case law 12 something Fish Eagle investment, whatever. We must share the details. I remember citing it in my applications when I dealt with levy collection, that unless the payer, the owner, specifically says, I'm paying 3,652 Rand and 1,000 must be allocated to this, 2,000 must be allocated to that, 52 Rand must be allocated to that, it goes towards the oldest debt first, which then technically means as long as a payment is being made, even if it is not sufficient to deal with the arrears or even the currents, that there shouldn't be an issue of prescription. I know that our colleague at Strata van Willy has had very strong opinions in regard to prescription, and that CSOS has always been of the view that levies do prescribe. And I know that there has been recent case law as well. Because we don't specialize in levy collection, I know that Razaan is doing so in his litigation practice. I prefer actually to focus on a webinar specifically for prescription and for levy. So Hazel, if you don't mind, if we can have an opportunity to go and look at the most recent case law and actually give you a considered answer as part of either a blog post or a webinar in the near future, I'd appreciate that. Would that be okay with you?
That would be fantastic. I'd be very, very grateful. Because it's come between two changes of managing agents, and they are actually not making any payments at all. So there's no money to allocate to the debt going backwards, if one wants to put it like that. That's the problem.
Yeah.
But the second question I have is that I have a matter that has been handed to the attorneys, and they came back and said that the owner of the property is a minor. And unable to pay the levy. Okay, all right. Now, we at the time of sale were not aware of the fact that the child was a minor. We did not specifically go and have a look and see the address, etc., etc. Sorry, the ID number. Only to find that when we issued action because she refused to pay levies, and she is using our water on a continual basis and is running a car wash from there, and it's really just abusing the situation. All right. Now, we have gone to a Section 65.
Yeah.
It's now gone on for 5 years. All right. Okay. So, and I've got the litigation from point A to point B, which everybody says, well, how can it have taken this long? So I said, well, I'm not quite sure why it's taken this long, but we are behind in the queue that says he was a minor. He's now 18, and now he doesn't have a job. So he still can't pay his levies. Now, my question basically just comes back to when the property was purchased and put in his name as a minor, should there then have been an undertaking, a written from the attorneys, or how would we have gone about making sure that our levies were due? Who was going to pay them, basically?
Razar, you'd be better suited, or maybe Razeen, to answer this. But if I think back to my years at varsity, you can't purchase property as a minor. You either need to purchase it in a trust, or there needs to be a guardian or
Yes.
a surety. So you shouldn't be having a situation like that, guys. What do you think?
100%. Yeah. I believe that hasn't changed till now, and that it just goes back to the same, contractual capacity and things like
Yes,
that.
yeah. You
Because
need to
I'm not
have
sure
a
if you have a
contracting
different view.
age.
Yeah, okay, there should have been a guardian that assisted them in concluding that contract.
Yeah, yeah.
Um,
And
All
almost
right.
stand as co-surety,
Well,
not so?
yeah.
Okay, sure. Well, essentially, it was my understanding at the time that the woman who we were dealing with, she claimed to be the owner. When she took over, we were always dealing with it with her, and she's, when I started asking her why she wasn't paying levies, she said, no, there's been complications, and never alluded to the fact that it was registered to a minor. Only then, when we handed the matter to the attorneys, the deed of sale come up and say, but this is it's registered to a minor, and yeah, okay. I think basically one's got to go back to that attorney and find out why it wasn't placed in a trust, and the validity then of the ownership, as what you say. It shouldn't be. He should not have had the rights to having that property registered in his name as a minor.
Or the obligations that flow from that ownership is directly attributed to somebody that has reached the age of majority, and it's that individual that you're going to pursue either as a co-defendant or a co-respondent, a second defendant or a second respondent.
As we tried to pursue her, sorry to interrupt you there, as we tried to pursue her, she was the one who came back and said, but I'm not the owner. Because we went for her as the owner, obviously, as the understood guardian, because that was, she had always posed, when I say posed, you know what I mean? She stood as the owner. She was our go-to. She was the person who took occupation, signed the documentation. And yet then when we tried to go ahead and issue a Section 65, she just basically said, no, actually, and then we went through to the deeds of office, find that we had we were dealing with a minor, and that was never disclosed to us.
There must be some documentation that was signed by a person of the age of majority. And you also want to avoid a Section 65 with levies, because the Section 65 is better for a debt that cannot be incurred any further. Like I owe money on my Woolies account. Woolies says, okay, until you make X payments, you can't use your card anymore. That's a Section 65 application. But I would recommend that you maybe engage with a conveyancer to go and do investigation at the deeds office to get the relevant person. And once you have that name, you pursue that person in your legal proceedings.
Okay. Thanks so much, Zerlinda. I really
No
appreciate it.
problem.
Thank you, Razeen.
No problem.
Okay.
You're welcome to
Thank
pop us a
you.
mail, and we can connect you with one or two colleagues if you need assistance.
I'd be grateful. I would be
No
so
problem.
grateful, because, as I say, the abuse in the situation has just become abominable. And
Yeah,
of course,
gee
it's
whiskers.
upsetting the rest of the residents in the scheme,
Yeah,
because they stand, they've taken liberties that we are not able to address in our normal set of rules, because she keeps saying, well, she's not the owner. And
yeah.
I mean, you can't evict her, or you can't, it's just a crazy set of circumstances.
Oh, obviously the age of majority changed from 21 to 18, and I was still of the older generation where the 21 was the year that you looked forward to. And during university, my parents invested in a commercial property, and they put it in my name for the purpose of using the rental income to pay off my studies. And
Right.
I remember the process of actually having to prove that I had reached the age of majority. And I remember being like, oh, I just turned 21, like, yay. So it was definitely a requirement. And as Razeen said, that hasn't changed. So that matter definitely needs
How
some.
did it get registered to a minor without a
Yeah,
trust or without a guardian,
yeah, definitely makes sense. Razeen, if you can maybe pop a question through to our one or two of our conveyancing colleagues. I think I'm like super interested in this, and I'd love to hear their view on it. Debbie, your hand is raised next.
Thank you so much.
No problem.
Hi. Razeen had started to answer my question. So mine was, is it reasonable to limit the keeping of firearms in a community scheme? So Razeen has answered that not necessarily keeping, but definitely their usage. And so then I had a second point to that, which was if the community scheme or the scheme is a retirement village, does that then change the limit?
So I think that doesn't necessarily change my opinion just because we live in a country where anything can happen in any sort of scheme. I do get, I obviously understand why you'd ask about a retirement scheme specifically, but I think that, and we do have it in our rules where we regulate the usage, with
Okay.
regards to this firearm. So I think that the answer would stay the same. Yes.
Interesting one, huh?
Okay, thank you so much.
Cool.
Yeah.
Thank you so much, everyone, for joining us today. We have really abused your time, so I appreciate that so many of you stayed online. Just a reminder that the recording will be made available. And until next time, we wish you a happy long weekend, and we'll chat to you all soon. Keep well, everyone. Bye-bye.